Hello, everybody.
Hello.
Good afternoon.
Hi, how was your spring vacation? Actually, I lost you guys. I changed on Wi-Fi. Did anybody do anything fun over the spring vacation?
Not at all.
Not at all. Gee.
Nah, I work full time too, so it's just another work week for me.
Um, any, any of the rest of you do anything interesting, or did everybody just do boring work?
Work or school work.
I see most of you have taken the test, although not everyone. So I think I'll hold off going through the answers to the test. Anybody have any difficulties with it technically, or anything sort of throw people off? Everybody's taken it so far as has passed. And so that's good. Okay, so today we're going to talk about the Lochner era, the so-called Lochner era of the Supreme Court, when laissez-faire capitalist impulses sort of ran wild on the Supreme Court. And then we'll turn to the President Roosevelt's attempt to sort of bring that era to an end by packing the court. And then this Supreme Court's switch, it was called the switch in time that saved nine, where Justice Roberts, not the current Chief Justice, but a previous Justice Roberts, switched sides from voting against all the New Deal legislation to voting in favor, and gave a 5-justice majority for upholding New Deal legislation. So that's what we're going to go through today. Then next week will be women's suffrage, 19th Amendment. There's a terrific PBS series on the 19th Amendment, which I recommend that you watch. And then there's a few chapters from the little book on women's rights that to read as well for that one. Okay, so remember when we were talking last week about how in the Reconstruction era after the Civil War, the Supreme Court read quite a bit of the meaning out of the Fourth Amendment, particularly the very first clause of the 14th Amendment says that the states can't deny people the rights and privileges of citizenship. And the Supreme Court very quickly established in the Slaughterhouse case and the case involving the Colfax riot in Louisiana that there was that this 14th Amendment only applied to federal citizenship, and that things such as the right to vote, which was at issue in the Colfax riot in Louisiana, were issues of state citizenship. And so the 14th Amendment didn't apply. so that's, and then you'll recall, we also talked about a couple of cases that were brought by women from the Midwest. I'm not just including them because they're from the Midwest, but because from Missouri and Illinois, but because these were important cases. Virginia Minor tried to get her, tried to argue that equal protection in the 14th Amendment should give women the right to vote. And the Supreme Court said, 14th Amendment didn't have anything to do with women's rights. Same thing in the Bradshaw case where I think it was Myra Bradshaw from Illinois passed the Illinois bar, and the Supreme Court said, I think I read the passage to you about how it's just against the laws of nature for women to have jobs such as being a lawyer. Their place was in the home and family. A view that you'll see persists in some of these cases that we're talking about today. But even though the 14th Amendment, the Reconstruction era Supreme Court read the meaning out of the 14th Amendment, a lot of meaning out of the 14th Amendment, it still was. I mean, it was the 14th Amendment was a constitutional revolution. And particularly when it came to reading more meaning into the due process clause of the 14th Amendment. So think about the 14th Amendment as having three especially important parts. Privileges and immunities of citizenship, with the Supreme Court read out of the 14th Amendment, the protection of life, liberty, and property can't be abridged by states without due process of law. That's often referred to as the due process clause. And then the equal protection clause which for the first time injected the value of equality, which had been in our founding document of the Declaration of Independence, but had not been in the Constitution, injected that back into the Constitution for the first time since the Constitution was ratified. So those are, and both the due process clause and the equal protection clause, sometimes in combination, have become extremely important. We'll talk a little bit today about the whole process of incorporation, by which the Bill of Rights, the protections of the Bill of Rights, most of them have been applied to the states, so that state actions that violate the Bill of Rights are unconstitutional. Also, the due process clause, together with the equal protection clause, are the basis of Loving versus Virginia, saying that laws against interracial marriage are unconstitutional, and for the basis of the same-sex marriage decisions, that there's a constitutionally protected right to same-sex marriage. Those are also, the due process clause is also the basis of a right of privacy to the extent that it exists in the Constitution. So right of women to have access to contraceptives, have access to abortion. We'll see how that is changed by this Supreme Court and this Supreme Court term. The right of families to decide whether to send their children to parochial schools. Back in around the 1900s, Oregon tried to make it illegal to send children to parochial schools. The right of a teacher to teach German in a classroom. Majority of the states outlawed the teaching of German in public school classrooms after World War I, or around the time of World War I. So the due process clause and the Equal Protection Clause became real powerhouses of the Constitution. And that's why the Reconstruction Era Amendment of the 14th Amendment is viewed as almost a new constitutional convention on its own. Before the 14th Amendment, none of the Bill of Rights applied to the states. So states could do could violate any of the rights in the Bill of Rights, and citizens had no recourse to protect themselves. So, by that I mean free speech, freedom of religion, free press, right not to have an established government tax-supported church, right to have guns, to be safe in your Fourth Amendment rights to be safe from unreasonable searches, right to have a lawyer, right to have, right to have a trial by jury, right to remain silent, right to be free from cruel and unusual punishment. All these rights that are in the Bill of Rights, they didn't apply to the states at all before the 14th Amendment. I'm not going to hold you to this, but there was a Supreme Court case in the 1830s called Barron versus Baltimore, in which the Supreme Court made that very clear. The Bill of Rights did only apply to the federal government. Somebody just sent me a note about being in Oregon. Trying to figure out who. Oh, I guess that's Jan Thompson. Okay, sorry. And so now a phrase that I want you to, a concept I want you to understand, and you'll see how it has changed over time, is what's called substantive due process. And by substantive due process, the substance is the specific right that's protected by the due process clause. And in the beginning, in the cases we're going to talk about today, Lochner and the other sort of wages an hour law cases, it was the right of contract, sort of the libertarian, laissez-faire, free enterprise system. Remember, this is the Gilded Age of when manufacturing is becoming so dominant. There's huge fortunes to be made in banks and railroads and all sorts of manufacturing enterprises. We're talking about the era of the oil, Rockefellers, Carnegies, etc. And so during this period of time, the Supreme Court used the property and liberty protected by the due process clause of the 14th Amendment to protect the right of contract. And it was very much based upon this laissez-faire view. So let's start with Lochner. This is called the Lochner because of this famous 1905 case, Lochner versus New York. Who would like to present Lochner?
I can do it.
Okay, you're on, Kayla.
Okay. I don't have my red book with me, so I'm just gonna go with what I remember.
Okay.
I believe it was New York that enacted a law, the Bake Shop Act, where it forbid bakers to work more than 60 hours a week or 10 hours a day. So Lochner was accused of letting an employee to work more than 60 hours in 1 week. So his first charge was a fine of $25 and the second was $50. What was it? He argued that the 14th Amendment should have been interpreted to contain the freedom to contract among the rights by the what's it called? Substantive due
Substantive,
process?
yeah, so the right of contract was part of the substantive, was a long-standing, long respected right that was amongst those that should be included as in the substance of due process. That you can't take it away. You can't take any of these rights away without some sort of due process of law. And what did the Supreme Court decide?
It was a 5-4 decision. The majority maintained that the law interfered with the freedom of contract and that the 14th Amendment rights, the 14th Amendment gave people the right to have the liberty and sorry, I keep getting emails, keeps distracting me.
No, that's okay. Go ahead.
My laptop just keeps beeping. Okay. They held that the New York law had failed to that it was just pretty much that the law was unconstitutional.
Yeah,
And that-
it interfered with the right of contract. And when they talk about the right of contract, so they're talking in terms of they have this sort of like I would say it's a pretense that that they're protecting the right of the worker and the right of the corporation. You know, it's a two-way street. The worker has a right to basically bargain away his entire weekend and his evenings and his chance to be with his family. You know, that's part of, if he wants to make more money, that's part of that should be part of his right. And of course, the manufacturers, the corporations, the railroads, all the industries, they have the right to run their corporations in the most efficient way possible. So they're protecting both people's rights. And the Supreme Court Justice Peckham, you know, says that there's no reason to believe that it's really any more dangerous to be a baker. We think that he says, we think that there can be no fair doubt that the trade of a baker in and of itself is not an unhealthy one to the degree that which would authorize a legislature to interfere with the right to labor and with the right of free contract on the part of the individual, either as the employer or employee. So then, as you said, there were a number of dissenters. One of them was the first Justice Harlan. I say the first Justice Harlan because his one of his descendants, to be honest with you, off the top of my head, I can't remember if it was his son or his grandson or another relation. I sort of think it was his son, was a justice of the Supreme Court in the 1950s, I guess 40s, 50s, and 60s, and was sort of a famous middle of the road justice. He wrote one of the opinions in the First Amendment case involving the anti-war protester during the Vietnam War who wore a "fuck the draft" jacket in a California courtroom. And Harlan, the second Justice Harlan, famously said, one man's vulgarity is another man's lyric," or something to that effect. So the first Justice Harlan, the one who is dissenting in this case, and writes one of the dissents, is famous for having been the dissenter in Plessy versus Ferguson. We'll read that case when we get back to school desegregation, but it's the late 1890s case in which the Supreme Court established the separate but equal regime, that the Equal Protection Clause of the 14th Amendment didn't require racial integration, but instead separate but equal education would suffice. And the first Justice Harlan was famously a dissenter to that Supreme Court opinion, which was ushered into the dustbin of history by Brown versus Board of Education in 1954, which said separate but equal did not comply with the Equal Protection Clause, and the Plessy versus Ferguson was wrongly decided. So Harlan writes one of these dissents, and he has an entirely, he points out that actually it's not very healthy to be spending 10 hours a day baking bread. I mean, we might all think baking bread's a great job, but the labor of bakers is, he cites a professor in his treatise on the diseases of workers, who says the labor of bakers is among the hardest and most laborious imaginable, because it has to be performed under conditions injurious to health. It's very hard work, great physical exertion, overheated workshop, unreasonably long hours, that there is workers weren't getting enough sleep, injurious, inhaling flour dust caused inflammation of the lungs and bronchial tubes, running eyes of bakers, rheumatism, swollen legs, etc. All sorts of long hours as a baker had all sorts of negative consequences for the health of bakers. And the other dissenting opinion was written by Oliver Wendell Holmes. And of course, Oliver Wendell Holmes is one of the most famous and important justices of the 20th century. If you've had my First Amendment course, we talk about him quite a bit in connection with first writing the decisions that said that the anti-war protesters of World War I didn't have a First Amendment right to oppose the draft and to oppose the didn't really have First Amendment rights during World War I, and then who by the next year in I think 1918 changed his mind and became a dissenter along with Justice Brandeis, and began and his was the first recognition of what has now become a very important part of the Constitution, that the power of the First Amendment, and so this is Justice Holmes, but we're talking here about 10 years. This is 10 years before the World War I period of time I'm talking about. This is 1905. So Teddy Roosevelt is the president. This is a booming economic time. There's lots of labor union strife. It's the beginning of the progressive era. There were these various muckraking journalists with writing exposés about the abuses of big corporations. And Holmes says this case is decided upon an economic theory which a large part of the country does not entertain. He says the 14th Amendment does not enact Herbert Spencer's social statics. Does anybody know anything about Herbert Spencer and this whole era of laissez-faire capitalism? He was let me see if I can. So this was the era of the where the economic the prevalent economic theory, at least on the Supreme Court, and really I guess in the country, in the Congress, was the economic theory of Adam Smith and 19th century social Darwinists like Herbert Spencer and William Grant Sumner, who was a Yale professor. So Spencer was an Englishman. He took the sort of, you know how we always think of Darwin as being the survival of the fittest. Well, he applied that to people. The fittest ought to survive. His Social Statics, written in 1850, argued against public education, health, and safety regulations, except to prevent nuisances. Argued against medical licensing and welfare, laws on welfare. And he said, those sufficiently complete to live do live, and it is well that they should live. If they are not sufficiently complete to live, they die, and it is best that they should die. So it's a fairly harsh, harsh view. You can't even find, I don't think you could find any politician or thinker to go out and make those kinds of arguments today. And Sumner, the Yale law professor, I'm not law professor, the Yale sociology professor said, the destitute are unfit, and the whole effort of nature is to get rid of such, to clear the world of them and make room for the better. So, this was also, it was after that kind of social Darwinism that the eugenics movement picked up steam, that laws were passed that required forced sterilization of some women. There's a famous case by the name of Buck versus Bell. Unfortunately, Oliver Wendell Holmes was on the wrong side of that one. He wrote the opinion upholding the forced sterilization of a woman. I can't remember if it was Virginia or North Carolina. And famously, Holmes wrote that, pointed out that this woman's mother and grandmother had been low functioning, and he wrote three generations of imbeciles are enough. It's not a high point in Supreme Court jurisprudence. That's a little bit later in like the 1930s. But it was the whole eugenics movement, which sort of grew out of this survival of the fittest, and that, we could use scientific genetic understanding to improve the human race. There was a person by the name of Hitler who took that to extremes. But there were even some eugenics supporters in the early who were involved in some of the early abortion rights and birth control advocacy around World War I. So what do you think about Lochner? I mean, does the Supreme Court have a point that there should be this right to contract and the government shouldn't interfere?
I think that it's a bit of it's a double-edged sword, and I only say that because without government interference, a company can get an employee maybe locked in some sort of contractual agreement or something like that that could be not very non-beneficial for them, but at the same time, it's almost like they do have the right to kind of do things as their own in their own industry, I guess you could say. So I'm kind of stuck between a rock and a hard place on the whole matter.
How about other folks?
In contracts class, when I was a law student, we learned that some contracts should be void because they're against public policy. For example, a contract to be a surrogate might be void because the surrogate might get attached to the baby and want to keep it as their own. So that's an example of a voidable contract because it has questionable public policy. Another example is a non-compete and non-disclosure agreement that in the movie The Insider, Jeffrey Wigand had with his with Philip Morris Tobacco Company when he was a senior executive there. They gave him a confidentiality agreement where he could disclose what he knew from his work there as a senior executive. And what he found out was that nicotine was addictive for the first time. So he disclosed that in a 60 Minutes interview with a journalist. I think his name was, I don't remember the name of the journalist, but it was a very famous one with 60 Minutes in the 1990s. And this became the subject of a movie because it was such an unfair agreement.
Probably it was the Wallace,
Yeah, that's the
Yeah.
one.
the father of Chris Wallace.
Yes, yes.
Yeah. Yeah, well, you're right. Contracts can be voidable for violating public policy. And so like, a lot of the non-disclosure agreements that President Trump, when he was running his company required. So, and then used to try to quiet employees from complaining about various things, including sexual assault. Those are widely held to be against public policy. But those are sort of like developments in contract law that are a few decades beyond the Lochner era. I be honest with you, I don't know whether or not there was a policy that there would have been any kind of legal decisions back then in the early 1900s that would void contracts based upon violating public policy. I just don't really know. I mean, it does seem in these decisions that the Supreme Court is saying that, when there are like extraordinary circumstances involved, that a terrible evil that the legislature is trying to avoid, that under those circumstances, you could have the regulation of the right to contract, but that they certainly don't consider the nice cushy job of working 10 hours a day in a bakery to be anything at all approaching that. And then we get
I
to
just saw the movie that I mentioned yesterday in my media ethics class, so it's fresh in my mind.
The Insider.
Yeah,
Who teaches that class?
Bill Babcock. He used to be a journalist, and he says that a lot of journalists get fed up and go into education. And I thought of you.
I'm not a fed up journalist. Journalism is my main occupation, not college professor or lawyer, or even though I am those things. I'm mainly a journalist. So he's mainly a college professor. Anyway, that's an interesting movie. And
Have you seen it?
I have seen it, but many years ago, like 20 years ago or something. It's about, as you say, it's about how the tobacco industry was able to cover up for so many years the ill effects of tobacco smoking and its addictive effects as well. And it's a great one to watch. I mean, it would be one, if you all, I think I say in the syllabus, I do this in my other classes, that if you want to get extra credit, you can watch a movie and write me a 400-word essay about the movie. That would be one that would be great to watch. So let's move on to Hammer versus Daggenheart. So now it's 1918. We're still in the Lochner era. Can someone present this case? This is the case involving child labor. This is so this is from North Carolina. The father, in his own behalf and as the next friend of his two minor sons, one who's under the age of 14 and the other between 14 and 16, and they both work in a cotton mill in Charlotte, North Carolina. And the father is suing to stop enforcement of Congress's child labor law. Pretty fairly incredible. So this law says that children under the age of 14 should be able to be employed, and those 14 to 16 should have shorter days. And the Supreme Court upholds says that the child labor law is unconstitutional. And it says that, you know, this kind of situation where Congress can get involved in trying to prevent something bad for society. There's got to be something where the actual act involved is evil. So they give their examples are the so-called white slave traffic law that made it illegal to transport a woman across state lines for prostitution. There was another court decision that banned taking women across state lines for debauchery. There was another one that related to enforcement of prohibition that made it illegal to take liquor across state lines. And so they were saying all of those things were stopping evils, you know, prostitution, abuse of women, alcoholism, but that child labor is not itself an evil. You know, the working, that's a good thing. And so the grant of power to Congress over the subject of interstate commerce was to enable it to regulate such commerce and not to give it authority to control the states in their exercise of police power over trade and manufacture. So child labor law, unconstitutional. Well, there's an interesting decision from this period of time when the Supreme Court takes maybe a slightly more positive view towards women, although still, you know, one that is highly questionable. It's a very patronizing view. Let me see if I can find. It's Miller versus Oregon. Just wanted to read you a little part of that. Maybe I better look it up. In the index. And it's basically, it basically upholds a limitation on women's work hours on the basis of them needing to be protected. Here, let me find it. Okay. 426 and 430. 476. Well, the index didn't help me. This is such a classic statement that I really want to read it to you. It is interesting as I'm thumbing through the decision in the child labor decision, that one of the things that Holmes is a dissenter in that one, and he says, if there's any matter upon which civilized countries have agreed far more unanimously than they have with regard to intoxicants and some other matters over which this country is now emotionally aroused, that's a shot at prohibition, is the evil of permanent and excessive child labor. Well, I'm not finding Miller versus Oregon. Suffice it to say that in that case, the Supreme Court upheld a law that limited the working hours of women and said it was necessary to protect them and their sort of gentle nature. When I come across it, I'll read it to you. So the substantive due process in these minimum wage, maximum hour, working conditions laws that the Supreme Court is striking down in the Lochner era, the substantive right that they're finding is the right of contract, and behind it is this whole social Darwinism, laissez-faire capitalist view of how the economy should work. That begins to run into problems. This whole line of cases especially runs into problems after the Great Depression and the passage of the New Deal legislation in the early 1930s. And there's a whole series, the Supreme Court in a whole series of decisions that are 5-4 finds that New Deal legislation is unconstitutional. And for many of the same reasons that are laid out in this whole Lochner era set of cases. And Roosevelt wins the 1936 presidential and congressional elections with a landslide. And he has such a huge majority in Congress that he proposes what was labeled by its opponents as a court packing plan, because it was a court packing plan. It would have given him the right to appoint 6 new justices to the Supreme Court, and who would easily be able to uphold all of the New Deal economic regulations that he was passing. And what happened what actually happened in reality was he couldn't get that through even the heavily Democratic Congress. And but it scared the Supreme Court enough that Justice Roberts switched sides. And so all the 5-4 votes going against New Deal legislation went the other direction. Pretty soon, Roosevelt had a bunch of appointments to the Supreme Court, Justice Murphy, Justice Black, and it was a very pro New Deal Supreme Court by the end of the 30s and through the 1940s. Yeah, precursor to the most liberal era of the court, the Warren era from 1954 to 1968. So the substance of but that didn't mean the end of substantive due process, because it turned out that the more liberal Supreme Court, the more progressive Supreme Court, had other kinds of process that it wanted to protect, and that turned out to be, rights of privacy, the right to access to abortion, to access to birth control. And there's the whole series, same-sex marriage, whole series of decisions through the 1960s, 70s, 80s, 2000s, up until the same-sex marriage decision of only about 5 years ago that recognized a new kind of substantive due process. The substance being those rights, and it being protected by the due process clause of the 14th Amendment. Any questions? Part of the reading was on how the Bill of Rights came to be incorporated through the 14th Amendment against the states. And there were three different approaches to this. Justice Black's, Justice Frankfurter's, and Justice Brennan's. So Justice Black had been a senator, a Democratic senator from Alabama. Actually, as a young man, he had been in the Ku Klux Klan. And he became a renowned Supreme Court justice, partly because he was very much of an absolutist when it came to the First Amendment. If you all think back to the Pentagon Papers case that some of us studied together, it was Black who took the absolutist view that the courts should never have stopped the New York Times from printing the secret history of the Vietnam War, even though they were classified documents. So he took the most absolutist view, and on incorporation of the Bill of Rights, he took the most absolutist view as well. His view was that all of the provisions of the Bill of Rights should be incorporated against the states. Justice Frankfurter, he was a Harvard law professor, like Oliver Wendell Holmes, and he had been in Roosevelt's kitchen cabinet. But when he was put on the Supreme Court, he actually he was very independent, and I would say he came out on the more conservative side probably more often than he did the liberal side. I'm thinking, for example, again, of a First Amendment case involving the Smith Act, Dennis versus the United States, where he came out upholding the Smith Act that made it illegal to be an officer of the Communist Party. And so Frankfurter took a more cautious view towards incorporating the protections of the Bill of Rights. He said that only if the right involved was, a fundamental right in the history of the United States, should it be incorporated. And Justice Brennan, who came onto the court in the 1950s, same time as Earl Warren, appointee of Justice Eisenhower, about President Eisenhower. Brennan was the liberal spark plug of the Warren era, but he was also the person who oftentimes moderated between the more conservative and more liberal justices, and so he came up with a middle ground. And his ground was that the protections of the Bill of Rights should be added piecemeal. The court should look at each one separately and decide whether or not it was a fundamental enough right to be incorporated against the states. And that is a process that's still going on. I mean, incorporation began, Griswold versus Connecticut. No. It's a different Griswold. There was a decision in the 1920s that involving the left-wing manifesto, sort of a socialist party newspaper, that for the first time the Supreme Court said, without even explaining exactly why, that clearly the First Amendment was one of the fundamental liberties that was protected by the 14th Amendment and should be incorporated against the states. So that was the beginning of incorporation, and it is a process that is still underway. The last case I know involving the issue of incorporation arose out of an asset forfeiture case, where the question was whether the excessive fines clause of the Eighth Amendment was incorporated against the states. We think of the Eighth Amendment as being primarily for the portion of it that says bans cruel and unusual punishment, but there's also a ban on excessive fines. And the question was whether or not civil asset forfeitures amounted to an excessive fine. It involved a guy who had a fancy car from which he dealt a drug. So a fancy car that was worth $40,000, and he was arrested for dealing heroin out of the car. And he was convicted of the heroin offense and fined $10,000. But they kept his car, which was worth $40,000. And so the question was, well, was that seizure of the car a fine, essentially an excessive fine? And Justice Ginsburg, who was then alive and still on the court, decided that, like 3 years ago, decided that it was the excessive fines clause of the Eighth Amendment should be incorporated against the states. Another recent part of the Constitution, of the Bill of Rights, that was incorporated against the states was the Second Amendment, the right to have a gun to protect yourself in your house. The Supreme Court decided sometimes around 2005, 6, 7, that the Second Amendment protected a person's right to have a gun to protect themselves in the District of Columbia, which was only federal jurisdiction. And so then there's a subsequent case from Chicago, a case called McDonald, and whether or not Chicago could ban handguns. And The Supreme Court said the Second Amendment is a fundamental right and it's incorporated against the states. So this process of incorporating parts of the Bill of Rights has been an ongoing one. And over a period of time, almost all of the important rights have been incorporated. All the rights in the First Amendment, to assemble, free speech, freedom of religion, freedom from a state church, right to have a gun, the Second Amendment. I guess the Third Amendment, right not to have to quarter troops, that has never come up. All the Fourth Amendment rights about free from unreasonable searches and seizures, right to a lawyer, right to remain silent, right to have a jury, all those criminal procedural rights, right to be free from cruel and unusual punishment. So that's been applied in state death penalty cases, excessive fines, as I just mentioned. So most of the rights in the Bill of Rights have been applied to the states, but through this sort of third route that Justice Brennan laid out of piecemeal incorporation. Any questions on all that? So sort of like over.
Do you want to give a 5-minute recap on the most important points of your lecture?
Yeah, actually, that's what I was just about to do.
Oh, okay.
So the overall the overview is that the 14th Amendment was essentially like a second constitutional convention. It was a rebirth of the Constitution.
Like Vatican II.
Like Vatican II, yeah, right. That's a good analogy, actually. I'll bet you there are folks on this call, though, who don't know what Vatican II is.
It's a council where they updated the rules of the Catholic Church.
Right, I guess in 1960s. So it's it's a while ago. Anyway, so it was like a new constitutional convention. I mean, it put into the Constitution equality. It has this important due process protection for life, liberty, and property, and becomes over the next over the 170 years since, becomes the source of all sorts of protections that Americans take for granted in their everyday lives. In the beginning, the Supreme Court read important parts of it out, important protections of the 14th Amendment out of the Constitution, primarily the first phrase on privileges and immunities, limiting that to federal citizenship and not applying it to state citizenship. And as a result, the 14th Amendment was not used very effectively for many years in connection with the right to vote. But then the court read all sorts of substance into the due process clause and expanded the protection of the equal protection clause, the equality protection of the equal protection clause. In the first years in the Gilded Age, in the Baker case, Lochner, in the Lochner Era, and the child labor case that we read, the substance it protected was this very conservative, libertarian, laissez-faire, social Darwinism approach to emphasizing the right to contract. But after the switch in time to save 9, where Justice Roberts switched sides and began approving of the New Deal legislation, the substance that the Supreme Court protected changed quite a bit. And it was primarily all of the liberties and freedoms protected, almost all the liberties and freedoms protected by the Bill of Rights, in addition to a right of individual liberty that a lot of people recognize as being privacy, and that relates to individual family decisions on where to send kids to school, whether to access to birth control, access to abortion, whom to marry. So it became a very broad reservoir, a very broad and deep reservoir of rights, of substantive rights protected by the due process clause of the Constitution. And hand in hand with the equal protection clause, became very, very potent. The equal protection clause, of course, as we'll study later when we talk about Brown versus Board, Plessy versus Ferguson, Brown versus Board, the equal protection clause expanded, beyond any of the frontiers, legal frontiers that could have been imagined by the people who wrote the 14th Amendment in the 1860s. It expanded to say that separate but equal did not satisfy the equal protection clause, that school segregation and segregation of buses and restaurants and hotels and public accommodations and swimming pools was all unconstitutional violation of the equal protection clause, and that equal protection, despite what the Supreme Court said in the 1870s to Virginia Minor and Myra Bradshaw, that it did encompass women, the persons did encompass women. And even though the Equal Rights Amendment, as we'll study later, has not yet been added to the Constitution, the Equal Protection Clause of the 14th Amendment has become the basis for protecting women against unequal conditions in connection with work and education and other economic opportunities. So the 14th Amendment was a revolution, a constitutional revolution. That's the summary. Other questions? The one point that we didn't talk about that was on the reading list, and it sort of encapsulates this to a certain extent, was footnote 4 of the Caroline Products Supreme Court decision. This is a New Deal era court decision. And I mean, the substance of the case is not as important as is the footnote itself, which is on page 515 of the textbook. And what it says in short is that from this point forward, the Supreme Court is going to pay a lot more attention to, fundamental kinds of rights, like the right to vote, that are important to a democracy working, and also to protecting minorities and insular minorities that may be discriminated against by majorities. And so this was a statement of this redirection of the Supreme Court abandoning that's a 1938 decision, abandoning the Lochner era of protecting economic liberty and setting off on this period of protecting instead all sorts of political freedoms and other kinds of and protecting minority groups that had not been well protected by the majoritarian process. Okay. Any other questions? Okay, well, plenty. I think we'll probably end there today. We'll have plenty to talk about next week. 19th Amendment. I'd really like you to watch that. It's a several hour long PBS documentary that's in the reading, but it's well worth watching. What you'll discover is that, you know, we sort of think today, well, I mean, of course, women were going to get the right to vote. It was a foregone conclusion. You know, it turns out that the 19th Amendment providing the right of women to vote only was finally ratified by the vote of Tennessee. I think it was a Tennessee legislator who cast the deciding vote, and it was a legislator whose mind was made up because his mom wrote him a letter and said, "Hey, I hear you have this big vote coming up. Think about your mother." So it passed by the narrowest of margins. So watch the documentary. It's really the best way to learn about it. We don't have any I don't have any Supreme Court decisions to read for this next week, but there are 3 chapters of the American Women's History short introduction that are worth reading as well. So that's what we'll do next week. Any questions? All right, we'll stop there. Thanks a lot. See you later.